Gubernatorial candidate Andrew Gillum has taken a strong stance in opposition to stand your ground. The purpose of this video is to analyze some of Gillum's comments and claims in relation to the law and check them for veracity. We're going to start by taking a look at an interview that Gillum did in August 2018 with CBS Miami.
Let's talk about some of the issues. You've made a considerable stand on the issue of stand your ground right now.
Yeah.
Particularly following the shooting in Clearwater where Marquise McLaughlin was killed.
That's right.
Talk to me about what your position is now.
Well, I tell you, first of all, my position has been this for some time. I think stand your ground is a dangerous law. It puts power in the hands of an individual, frankly, to snuff out the life of somebody that they may feel threatened by. In the case of Marquise McLaughlin, yes, he physically shoved the shooter, and I don't condone that at all. But I will say there was not an action taken by Marquise McLaughlin on that day that should have resulted in a death sentence. And unfortunately, stand your ground allows for vigilantes to take the power to be the judge, the jury, and the executioner all at once.
So you believe that man was a vigilante at that point?
I do. I absolutely do believe that, and partly because we enable it. I think stand your ground law, which took Castle Doctrine, which in my belief is sound doctrine, which basically says that if someone intrudes upon your house, your property, that you have the ability and the right to defend yourself and your family. And what that did is it took it into the public square, and then through this very subjective formula, basically, if you feel threatened, you have the ability and the right to defend yourself with life-taking measure. In my opinion, that's unreasonable law and has no place in civil society.
In this interview, Gillum made two substantive claims about stand your ground. The first is that, quote, stand your ground puts power into the hands of an individual to snuff out the life of somebody they may feel threatened by. Is Gillum right? Does stand your ground in fact give someone the power to snuff out the life of another? The answer is no. Contrary to what Gillum claims, stand your ground did not give any new power to use deadly force. The legal doctrine for justifiable use of deadly force dates back to British common law, where it was implemented centuries before the United States even came into existence. Now, Florida adopted this common law doctrine in 1892. So what did stand your ground change if it didn't grant any new power to take life? Well, stand your ground simply says that you do not have a duty to retreat from a public place before defending yourself. You see, prior to the enactment of stand your ground, if you were attacked, you did have a duty to retreat, if possible, before you could defend yourself. In fact, you had to use, quote, every reasonable means within your power to retreat before defending yourself. And if you failed to exhaust every reasonable means within your power and ended up taking someone's life in your own defense, you would be prosecuted and likely convicted for manslaughter. Now, as you might suspect, this doctrine of duty to retreat has resulted in a lot of really bad results and a lot of really bad cases that people don't like. Stand your ground was passed to remedy these injustices. It says, quote, a person who uses or threatens to use deadly force in accordance with this statute does not have a duty to retreat and has the right to stand his or her ground, close quote. In other words, it does not change the centuries-old law in respect to when you can use deadly force. It simply says this applies to public places where you have a right to be. Now, the second claim that Gillum makes is, quote, through this very subjective formula, basically, if you feel threatened, you have the ability and right to defend yourself with life-taking measure, close quote. In other words, Gillum is claiming that stand your ground allows one to kill by a subjective standard. Is he right on that claim? Again, the clear answer is no. Stand your ground doesn't apply any standard. As I just told you, the analysis of whether or not a person can use deadly force relates to the legal doctrine of justifiable use of deadly force. That's been the law in Florida for over 126 years. So Gillum is wrong to attribute this standard to the stand your ground law. More importantly, he's wrong that he says the standard is a subjective one. The standard is whether or not the defender, quote, reasonably believes that deadly force is necessary to prevent imminent death or great bodily harm. Secondly, note that the standard says one must reasonably believe. This makes it an objective standard, not a subjective one. For it to be a reasonable belief, it means that reasonable people of goodwill can look at the situation and agree that the threat was sufficient to warrant the use of deadly force. Now, contrary to what Gillum claims, you can't just kill someone because you're a particularly sensitive person and you felt threatened in some way. No, you have to be threatened in such a way that any reasonable person would agree with you that death or serious bodily injury is imminent if you don't act. In addition to being wrong on the substance of the law, Gillum also engages in some shameless demagoguery in this interview that you just watched. For instance, in the interview you just watched, Gillum claimed that stand your ground allows, quote, vigilantes to be the judge, jury, and executioner, close quote. Mr. Gillum, that is absurd. For one thing, it's offensive to suggest that victims of violent crimes who happen to defend themselves are vigilantes. For two, stand your ground doesn't make anyone the judge, jury, and executioner. It simply allows people to utilize pre-existing common laws in relating to self-defense in public spaces. Now, if Gillum doesn't like that someone can use deadly force to defend himself, then Gillum is taking issue with our centuries-old common law, not stand your ground. Also, when someone is the judge, jury, and executioner, it means his or her actions cannot be questioned. Obviously, that's not the case when someone uses deadly force in self-defense. On the contrary, your actions will be almost certainly scrutinized, and you may very well be prosecuted for your action. So Gillum is being intellectually dishonest with this comment and attempting to rouse the emotions of those who are easily roused on the topic. Now, the next comment that Gillum makes is that, quote, stand your ground has no place in civil society. Really? Why is that, Mr. Gillum? Why is it uncivil to allow self-defense in public spaces? And since when does civility mandate that those who are attacked with deadly threat must allow themselves to be victimized? Now, the reality is that stand your ground exists in 31 states, making it the clear majority law, meaning that it is clearly preferred to the duty to retreat doctrine. Of course, reasonable minds may differ about whether stand your ground or duty to retreat is the better law, but it's silly to claim that one or the other is uncivilized. Finally, there's one other aspect of Gillum's policy on stand your ground that deserves scrutiny. Take a look.
As I understand your position, and clarify it for me, if you're elected governor, you will suspend that law?
Yeah, I mean, what we
do you have the legal authority to do that?
Yeah, well, let me be clear. What we have asked is for Governor Rick Scott to use his executive order and declaring emergencies, which allows him to suspend any law for 60 days. And it can only then be continuously extended by him every 60 days. And what we're saying, and by the way, I use the language that the NRA used. They basically said that they believe that the sheriff in this case erred, that he actually had the power to make an arrest, and that they believe he's misinterpreting the law. Well, when you create this kind of confusion, when this kind of uncertainty exists, and at the end of the day, an individual is allowed to apply this law in their own understanding and snuff out the life of an otherwise innocent person, to me that is an emergency, especially when you consider that communities of color are disproportionately impacted by the application of this law.
But this could set a very dangerous precedent. You have a legislature, duly elected by the people, that whether you like this law or not, passed this law.
Absolutely.
And should you really, as the governor, have the ability to stymie the will of the people, in essence, through their legislative body, to enact laws? Doesn't that set you up as a king?
Well, let me be very clear. I do believe that ultimately the legislature needs to resolve this issue. I absolutely believe that this is in the legislative domain. However, the legislature is not in session, and they're only in session 3 months out of the year. And in the interim period of time, you have people's lives that are being put at risk and are at stake. Now, in
this segment that you just watched, Gillum claims that he would suspend the law, which I find very disconcerting. Not just because he's misinformed about the law, but because it would be way beyond the scope of his authority. Note the interviewer calls Gillum out on this point. He said, quote, "Wouldn't that make you a king? Isn't that a legislative action?" Now, Gillum seems to admit that changing the law does fall within the purview of the legislature, but that he would suspend the law nonetheless. A willingness to violate the separation of powers doctrine is not what we Floridians need in a governor. In conclusion, it's clear that Gillum doesn't understand stand your ground or the doctrine of justifiable use of deadly force. He's wrong when he claims stand your ground gives power to snuff out life. He's wrong when he claims that stand your ground allows for a subjective formula. Moreover, Gillum's demagogic statements are beneath him and poison the election process. If Gillum wants to oppose stand your ground, he's free to do so, but he should not misrepresent the law and manipulate people's emotions while doing it. Finally, Gillum compounds ignorance with a willingness to violate the separation of powers doctrine. He's passionate to change that which he doesn't understand and is willing to ignore constitutional protections to effect such a change. This makes him not just a poor candidate to lead the state of Florida, but a dangerous one.